Each story you hear on Planet Money starts with a question. What happens if we refund tariffs? Why are groceries so expensive? At NPR, we stand for your right to be curious because the forces shaping our world can be hard to see. Follow NPR's Planet Money wherever you get your podcasts and start seeing how the economy really works.
Funding for the Think podcast comes from Wise, an app for people using money around the globe. With the Wise account, you can send, spend, and receive in up to 40 currencies. You can download the Wise app or learn more at wise.com. Terms and conditions apply.
I feel like I'm a work in progress with my personal style, but lately I've tried to choose things that are classic and well-made and not trendy, but just work in a lot of different combinations. Quince is a great place to start for clothes like this. The fabrics are elevated, the fits are flattering, everything just sort of works without having to overthink it. Quince makes it easy to refresh your everyday look this spring with pieces that feel as good as they look. They use a lot of premium materials like European linen and organic cotton and ultra-soft denim. They have lightweight linen pants and dresses and tops starting at $30 that are breathable and easy to wear on repeat. I was super excited because I needed a new handbag for the summer, and I went on the website and found a diamond-stitched sling bag that is currently winging its way to me. I'm very excited to receive it. Everything at Quince is priced like 50 to 80% less than similar brands because they work with ethical factories and they cut out the middlemen, so customers are paying for quality and craftsmanship rather than brand markup. I like the things at Quince that are made out of silk, which are almost always washable. They feel amazing on the skin, and they really are a lot less expensive than similar items elsewhere. Refresh your everyday with luxury you will actually use. Head to quince.com/KERA for free shipping on your order and 365-day returns. Now available in Canada as well. That is quince, QUINCE.com/KERA for free shipping and 365-day returns. Quince.com/KERA. This year, the Supreme Court has already announced rulings knocking out a once major part of the Voting Rights Act and declaring conversion therapy protected under the First Amendment's free speech guarantees. And as habitual court watchers know, the big decisions for 2026 are just getting started. From KERA in Dallas, this is Think. I'm Chris Boyd. Still to come are rulings on transgender students playing sports, IQ testing for criminal defendants who claim intellectual disability, and whether the 14th Amendment really does grant birthright citizenship to pretty much everybody born in the United States. And as those decisions come down in the next few weeks, we can expect the justices who issued them to be out and about making the case to the American people that they, as individuals, are devoted to the project of objective constitutional interpretation, not partisan boosterism. For insights on the rulings this heavily conservative majority court is likely to release, we've invited Ian Millhiser. He covers the court as a senior correspondent at Vox, where you can read his reporting on what the Supreme Court still has left to decide this term. Ian, welcome to Think.
It's so good to be here. Thank you so much.
Why, by the way, does the court have this schedule that it has when it releases like a ton of consequential decisions over the course of a few weeks and then heads out of town for 3 months?
Yeah, I mean, being a Supreme Court justice is a sweet, sweet job. Like, only justices and school children get the summers off. And so the reason why the court, I mean, the court does have a schedule that's written into statute where it has year-long terms. The new term begins in October. And so if it's going to stick with its terms, it has to wrap everything up by October. But the reason that they wrap everything up in late June is because they want to go on vacation in July, and they have to finish their work before they can do that.
Maybe it is an exhausting job. The New York Times reported recently about hints of these strained relations among the justices. Surely there have always been stark ideological differences. What is different now?
Yeah, I mean, the court has always been political. It's always been ideological, but it is more partisan now than it has ever been. And I think the reason for that is just that Democrats and Republicans have just had more consistent ideologies for the last 40 or 50 years than they have, like, if you look back over the long arc of American history, there's been a Democratic Party and a Republican Party for a long time, but they haven't held to these consistent views about not just how they want to govern, but what they view as the role of the judiciary for very long. And so if a Republican appoints a judge, we know that judge is going to be anti-abortion. We know they're going to be anti-affirmative action. We know they're going to support expansive legal exemptions for religious conservatives. And, we know several other things about them. And we know that Democrats will want the opposite thing. And this is a fairly new development. As recently as 2010, there was a liberal Republican, Justice John Paul Stevens, on the court, and that just isn't true anymore. The court has sorted into partisan camps.
So far, President Trump has been able to appoint 3 Supreme Court justices. Is there any indication, Ian, that those justices feel beholden to him somehow and might deliberately seek to reach decisions that benefit the president?
I don't think that, with maybe one exception, any of the justices wake up in the morning and say, what can I do to benefit the Republican Party, or what can I do to benefit the Democratic Party today? What I do think is true, though, is that these justices are heavily vetted. The way that you become a justice is like the White House reads everything that you've ever written, everything that you've ever said before. If you're on the Republican side, there's the Federalist Society, which is often vetting potential judicial nominees as soon as they enter law school. Democrats don't have anything as formal as that. And so by the time someone is confirmed to the Supreme Court, you don't need them to ask the question, what can I do today to benefit my political party? Because the whole reason they got the job is that they were vetted to make sure that they already believed whatever the president and the White House that is appointing them already believed.
You said that it doesn't work in such a way as the justices wake up in the mornings and think, what can I do to benefit the president? But then you drop this tantalizing little bit on the end and you said, but with one exception. Who might that exception be?
I have nothing but bad things to say about Justice Samuel Alito. I think that Alito does have a pattern of handing down inconsistent rulings, making arguments that are inexplicable by anything other than partisan politics. But with the exception of Alito, I think that the other 8 justices, again, they reach partisan results because they were vetted to make sure that they sincerely believe the things that their party believes, and not because they're constantly readjusting their views so that if the Republican Party believes something different on Wednesday than it did on Tuesday, that they'll adopt the Wednesday view.
Okay, so the Supreme Court agrees to hear several dozen cases each year, amounts to about 60. Then there is the shadow docket as needed. Will you just remind us of how shadow docket cases are different from standard constitutional challenges?
The short answer to that is that it's increasingly unclear how different they are. So where the shadow docket comes from is it used to be that death penalty cases were often heard on a very expedited basis for the simple reason that if the Supreme Court didn't decide right away that someone should not be executed, then that person would be executed, and then the case would be moot because the person would no longer be alive. And so the Supreme Court had to have this emergency process where it could issue temporary orders to say, don't execute this person until we have enough time to give the case full review and decide whether they should be saved permanently or not. And during the first Trump administration, the Supreme Court started using this process, which historically was used mostly in death penalty cases, only very, very rarely in other instances. They just started using it all the time. The Trump administration started asking the Supreme Court to intervene and temporarily block lower court opinions because that had gone against Trump. The court started granting those requests very, very often. And, once lawyers realize that the Supreme Court could potentially give relief to their clients, they're going to start filing motions asking for more relief. And so it's now metastasized into something huge. On top of that, there have been some cases where the court said something on the shadow docket that was inconsistent with something that it had said in a precedent that had been on the books for a long time. And then some of the justices have said, well, you should have followed a shadow docket ruling. And some lower court judges have expressed confusion when they don't know when a shadow docket ruling has overruled a precedent that was handed down on the merits docket. So I guess my long answer to your question is that the status of the shadow docket is a bit unclear, but it is something that seems to be rapidly expanding.
Okay. Last month, we received the ruling for a case called Louisiana v. Calais.
Yeah.
What was at stake there?
This is probably the biggest case of the term. So there is a federal law, the Voting Rights Act, that was amended in 1982 to say that, among other things, it made it so that some states had to have a minimum number of majority Black or majority Latino districts. This was in states where mostly Black voters were residentially segregated and where there was what was called racial polarization. So Black people voted for Democrats, white people voted for Republicans, and when you have those two things, it tends to lock the minority group out of power altogether. And so the Voting Rights Act had been interpreted since the 1980s to say that there has to be a minimum number of Black seats and in some cases majority Latino seats in some states. The Supreme Court just effectively repealed that 1982 law. And so what that means is that almost immediately after the Supreme Court did that, we saw Tennessee and Mississippi and Alabama and Louisiana. All these states have begun the process, and in some cases have completed the process of redrawing their maps to make them whiter, more Republican.
Okay, so do I understand this correctly, Ian? It is now officially legal to gerrymander for political advantage and officially illegal to gerrymander to preserve the collective influence of historically marginalized voters.
Basically, yes. So what the law, there have been two big cases in this space. The first was about 7 years ago, was a case called Rucho. So prior to Rucho, the Supreme Court had never actually declared a partisan gerrymander down. And a partisan gerrymander means that the map was drawn in order to benefit a political party. The Supreme Court had never actually struck down a partisan gerrymander, but it had said a few times, watch out, states, like we might do it in the future. We might at some point strike down your maps if they're too partisan. And the states had been a little cautious because they knew that the Supreme Court might intervene if they pushed too far. And in this Rucho case in 2019, the Supreme Court said, never, ever, 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 ever going to do it. We're never going to strike down a partisan map. States go do whatever you want. And then this Clay decision, it is still illegal to draw some kinds of racial gerrymanders. So, like, if Mississippi were to pass a map tomorrow and they called it the "We aren't letting Black people have any congressional seats Act of 2026," and they made it really, really clear that the intention behind the map was to disenfranchise Black people, that would still be illegal under Clay. But what Calais said is that essentially states can use race as a proxy for partisanship. So in a state where white people vote for Republicans and Black people vote for Democrats, if the state wants to if the state wants to minimize the power of Democrats, they could draw the maps in a way that minimizes Black voting power, knowing that that will have the effect of cutting Democrats out of representation as well.
What does that mean for Republican efforts and, frankly, success under President Trump to draw in voters of color to the GOP?
I mean, the short answer is you'd have to ask the voters. I mean, if I were a voter who was trying to decide who to vote for, and I knew that my party had just tried to limit my representation in Congress, I would be inclined to vote for the other party. But of course, the point of gerrymandering is to make it so that it doesn't matter what the voters who are cut out of power think. So like in Tennessee, for example, they just drew a set of maps to make, the goal of these maps is to make it so that every single congressional seat is controlled by a white Republican. Maybe that won't work, but if it does work, what that will mean is that it won't matter what black people or what Democrats in Tennessee think, because they won't have representation in Congress.
What is the court considering in National Republican Senatorial Committee v. FEC, which of course stands for Federal Election Commission?
Yeah. So this is the latest campaign finance case, and the actual issue in this is like technical enough that I've tried to think how to describe it without putting your listeners to sleep. So it deals with if you give money to like the DNC or the RNC political committees, you're allowed to give much more money than you could give directly to a candidate. And the question in this case is, if I give like a $40,000 donation to the DNC, it would be illegal for me to give that money directly to it, that much money directly to a candidate. Can the DNC then coordinate directly with the candidate about how that money is spent? So it winds up being the same thing as if I had just written a big check to the candidate. The main thing to know about this case is that the court's Republican majority really hates campaign finance laws. I mean, with one exception, every campaign finance case I could think of going back to Citizens United was a partisan divide in the court with the Republicans voting to strike the law down. And so I expect they're probably going to strike this law down. I also am not quite sure that it's going to matter so much, just because the Supreme Court has already burnt so much of American campaign finance law to the ground that this one marginal question about what happens when you give money to the DNC or the RNC, what can the DNC and RNC do with it? I mean, it just doesn't matter that much because there's so many other ways that very, very wealthy people can influence elections now.
Ian, what sort of influence, going back to National Republican Senatorial Committee versus FEC, what sort of influence does that give deep-pocketed donors with specific candidates?
Yeah. So that is the concern underlying this case, is that the one thing that the Supreme Court thus far has not touched is there are fairly low limits. I believe it's around $3,000 a year for what someone can give directly to a candidate. And the theory behind those limits is that, running a House race costs hundreds of thousands of dollars. Now, running a Senate race costs millions of dollars. And so if someone writes a $3,000 check to the candidate, the idea is that that candidate probably isn't going to feel so beholden to that individual that they're likely to enter into some sort of a quid pro quo, like, for your $3,000, I will do this for you. But the more money that's involved, the more likely you get that kind of like direct sales operation where, the candidates maybe just selling their votes in return for big donations. The question in the case that's in front of the Supreme Court right now is whether these party committees can essentially be used as pass-through entities. So can a big donor write a check that's much larger than what they could write directly to a candidate, give it to the DNC or the RNC with sort of a wink and a nod saying, by the way, I want you to spend this money on John Smith's campaign. And then the DNC or RNC calls up John Smith and says, hey, we got this $40,000 check. What do you want us to do with it? Oh, and if you want to express any gratitude towards the person who wrote it, here's the person who wrote it. So like the law is intended to prevent that kind of arrangement.
Okay. Watson v. RNC is a case about date requirements for mail-in ballots. Why is the RNC trying to change the rules by which these votes are counted? Votes that people fill out, put in the mailbox, and expect to be counted.
Yeah, I mean, this is a very unfortunate case. So up until really before Donald Trump emerged on the scene, both parties were fairly supportive of absentee voting. People like it to be convenient to vote. Some people are overseas, some people are in the military, and their only option is to mail in their ballots. And until very recently, both Democrats and Republicans were generally supportive of mail-in ballots. And then during the pandemic, Democrats really started organizing their voters around mail-in balloting. They had been trying to get people to vote early and to mail their ballots before that, but it really kicked off during the pandemic. And Donald Trump noticed this and started, openly criticizing mail-in voting, started, pushing for laws to make it harder to vote by mail. And I mean, there's a pretty transparent reason why he was doing that, is because he saw more Democrats were voting by mail than Republicans. And so he thought that if he made it harder to vote by mail, he would make it harder for Democrats to vote. What this Watson case deals with is many states, and like I started off by saying that this used to be a nonpartisan issue. The state at issue in Watson is Mississippi. So Mississippi, a pretty Republican state, is one of the many states that has a law which says if you mail your ballot before the election, but for whatever reason it's stuck in the mail and it doesn't arrive at the polling place until after election day has happened, you get a grace period where so long as it's postmarked before the election, your ballot will still be counted if it arrives in that grace period. The Republican Party wants that grace period declared illegal. I frankly think that their legal theory in this case is exceedingly weak. And the reason why I think they are pushing for this is that, again, it goes back to the fact that during the pandemic, Donald Trump noticed that Democrats were more likely to vote by mail than Republicans. And so he's trying to make it harder for Democrats to vote.
What you remind us that the president did lose one big case this term. What was the question in Learning Resources Inc. v. Trump, which is a case about something it doesn't sound like it's about?
Yeah, no, this was the tariffs case.
Yeah.
Donald Trump had these very large and frequently shifting tariffs. He was relying on an emergency statute, which said that he could regulate trade under certain circumstances with foreign countries, but it used that word regulate. It didn't say that he could tax. And so the question was whether the power to regulate commerce with foreign nations included the power to tax those transactions. And the Supreme Court said, no, that is regulate does not mean tax. That is not something that the president can do using this specific statute. Now, the tariffs issue remains live. There's a whole other case going on right now because Trump tried to reinstitute some of the tariffs by invoking a different statute that lets him issue tariffs under different circumstances. A federal court just said that his second round of tariffs is also illegal. And, that's going to go up to the appeals courts, and we'll find out what the Supreme Court says about that eventually. So the tariffs issue is not over. But the court said in this one case, yeah, he's not allowed to use that statute. And I think that was a very revealing decision because, like, remember I said at the beginning of our interview, the way that partisanship works in the Supreme Court is when the justices are chosen, they are heavily vetted. And they're heavily vetted to make sure they agree with what the White House believes right at the moment when they were chosen. But the fact that they were vetted to make sure that they believe what their party believes at the moment they're chosen doesn't mean that they're continually updating their beliefs. And the Republican Party used to be a free trade party. And so, all three of the court's Democrats voted against Trump in the tariffs case. The six Republicans split right down the middle. And I think that makes perfect sense because the Republican Party is split on whether it is still a free trade party. And you see that divide reflected amongst the justices, just like you see it reflected amongst rank and file Republican voters.
You said maybe the most important case of this term was Louisiana v. Calais. Maybe the most watched is this case, Trump v. Barbara, which is a challenge to the 14th Amendment provision of birthright citizenship.
Yeah.
What arguments did the president's lawyers make to show that the 14th Amendment was never intended to extend automatic citizenship to babies born in the U.S.?
Yeah, I mean, they're trying to relitigate a case from the 1890s, or I think from the 1880s, called Wong Kim Ark. So the 14th Amendment to the Constitution says that everyone born in the United States and subject to the jurisdiction thereof is a citizen of the United States. So if you're born here and you're subject to U.S. jurisdiction, those are the two things that you need to be automatically a citizen.
Sorry for interrupting. The small carve out is for like the babies born to diplomats who are serving here, basically.
That's right. Yeah. Okay. So the word jurisdiction means that you're subject to a nation's law. Mm-hmm. So jurisdiction comes up all the time. If I am sued in, say, the Northern District of Texas, I'm going to say, well, I don't live in Texas. I haven't been to Texas for a really long time. The Texas courts don't have jurisdiction over me. That's what jurisdiction means. It means, does this government entity have power over me? If if it were true that what Trump wants to argue is that undocumented immigrants and some temporary residents are not subject to the jurisdiction of the United States, that's obviously not true. If undocumented immigrants weren't subject to the United States jurisdiction, that would mean that if an undocumented immigrant robs a bank, the federal government couldn't prosecute them because the immigrant would be beyond the legal power of the United States. There are people who are beyond the legal power of the United States. And in modern day America, that is people have diplomatic immunity. And then the Kim Ark opinion also pointed to a few other categories: invading armies, which thankfully is not a problem we've had to deal with very much. And then also at the time the 14th Amendment was written, several members, tribal nations, Native Americans, some Native Americans were considered to be citizens of their tribal nation. They weren't necessarily considered citizens of the United States, and so they were considered beyond the jurisdiction of the United States. There was a law passed during the Coolidge administration which says that everyone, whether you're a member of a tribal nation or not, if you're born here, you're also a U.S. citizen. But this was before the Coolidge administration. So back then there was also a carve out for American Indians. But beyond today, beyond people who have diplomatic immunity, again, if you're in the United States, if the government can prosecute you for it because you rob a bank, that means that you are subject to the jurisdiction of the United States.
Most people don't realize how much of their personal information is being bought and sold every day. Data brokers are making billions pulling details about you from public records and the internet, then packaging and selling it, usually without your consent. That's how your information lands in the hands of scammers, spammers, even stalkers. It's why you get endless robocalls and why ads seem to follow you everywhere. That's where Aura comes in. Aura actively removes your data from broker sites and keeps it off. They also instantly alert you if your information shows up in a breach or on the dark web. But Aura goes beyond data protection. With one app, you get a VPN, antivirus, password manager, spam call protection, dark web monitoring, and even up to $5 million in identity theft insurance, all backed by 24/7 US-based fraud support. Other companies might sell just credit monitoring or just a VPN. Aura gives you all of it together at the same price competitors charge for just one service. Start your free trial today at aura.com/safer. Protect yourself now at aura.com/safer.
So why would birthright citizenship be challenged in this way now after well over a century of being just broadly accepted as something that we have in this country?
Yeah. I mean, the short answer is that, political parties sometimes adopt a view that they didn't hold before. I mean, sometimes for very good reason. I mean, Franklin Roosevelt decided to invade Germany. I don't think that would have been a good policy in the 1920s, but it made sense when he did it. So sometimes parties change their mind about policies, and sometimes they do it for good reasons. But in this case, the Constitution is just very, very, very clear, and it has been settled since the late 1800s that if you were born in the United States, unless you fall into this very narrow exception for people with diplomatic immunity and the like, you are a citizen, period.
And the indicators you've seen based on, the behavior of the justices while this case was being argued before them says that President Trump is likely to lose this one. It's not likely to go his way that we revoke birthright citizenship.
That's right. Yeah, I mean, I counted as many as 7 votes against Trump. This doesn't seem to be an issue that's going to divide the justices too much. And again, for the same reason I wasn't surprised by the outcome in the terrorist case, Trump's adoption of this view that birthright citizenship, that the Constitution doesn't say what it means when it comes to birthright citizenship. This is a very recent development. It wasn't the position of either the Democratic or the Republican Party as recently as 10 years ago. And so I'm not surprised that all of the Democrats and most of the Republicans on the Supreme Court are sticking with the view that has been the law since the late 1800s, and they haven't updated their view to align with the new view that the leader of the Republican Party holds right now.
Ian, you say the president is likely to prevail in Trump v. Slaughter. What is that case about?
Yeah. So this is the legal term for these cases is unitary executive. And what the issue is here is there's a bunch of agencies, the Federal Trade Commission, the Federal Communications Commission, the Federal Elections Commission. There's a bunch of these agencies that are what are called independent agencies. And that means that Congress decided that once someone is appointed to lead these agencies, they have some protection from being fired. So the president still picks the people who lead these agencies, that those people have to be confirmed. But once they are confirmed, the law says that they serve for a period of several years, and the president can only fire them for cause like malfeasance in office or corruption or something like that. And in the Slaughter case, Trump wants to fire someone who was appointed to the Federal Trade Commission before her term expires. And the question is, does the president have the inherent authority to do that? And the Republican Party's position on this issue, going back, like Dick Cheney was a huge fan of the unitary executive. This is a longstanding view of Republicans: is that the president should control every single federal agency, period, and that means that the president must have the power to fire the leaders of those agencies. Where the court appears likely to land is that I think they're going to adopt the unitary executive theory. I mean, they've been very pro-unitary executive in past decisions, with one exception, and that is the Federal Reserve. There's another case this term involving the Federal Reserve, and it looks like the court is going to say that there is a Federal Reserve exception to the unitary executive.
Is there much evidence for the unitary executive theory in originalist interpretations of the Constitution?
I mean, sort of. So, like, where the unitary executive theory comes from is there is a provision of the Constitution that says that the executive power shall be vested in the President of the United States. And so there's this thing called the executive power, whatever that is, and all of it belongs to the president. Again, whatever that thing is, the president controls it. And so the idea behind the unitary executive is that these agencies like the FTC and the FEC and so on and so forth are all wielding some kind of executive like authority, and therefore they must be controlled by the president. Now, if you go back to the founding, what you find is that the founders didn't really have that clear of a sense of what was executive and what was not executive. Like one thing that the Supreme Court, they said that it's this in Trump v. United States, the Trump immunity case from a few terms ago, is they said that one reason why Trump is allowed to order the Justice Department to target his enemies is because the president has full control over prosecutions and investigations of potential crimes, and that is part of the unitary executive theory. But if you go back to the founding, what you find is like frequently prosecutors were appointed by judges. There's debate amongst historians about when this practice ended, but at least at some points in American history, it was very common to have private prosecutions where the way that a crime would be prosecuted is that a private lawyer would go to a grand jury and say, my client wants this person indicted for a crime. Will you indict them? And then if the grand jury said yes, that private attorney would then prosecute the person. So, like, at the founding, it's not very clear that prosecutions and investigations of crime was exclusive to the executive branch of government and to the president. But, like, it is true that, like, the Constitution does say that there's this thing called the executive power that belongs to the president. I think the Supreme Court is expressing more certainty about what those words executive power means than they can justify using the historical record.
Ian, what can you tell us about these two cases that take on temporary protected status for
Yeah.
Syrian and Haitian nationals?
Yeah, these are the Doe and I believe it's pronounced Mayotte cases. One deals with Syrians, one deals with Haitians. So temporary protected status is basically, it applies to people who are visiting the United States, often are in the United States lawfully, when something goes terribly, terribly wrong in their home country. So, like, imagine that you are a tourist from, let's say, France, and you are vacationing in New York, and while you are vacationing in New York, there's a civil war in France, and all of a sudden it is unsafe for you to return back to your French home. Temporary protected status is humanitarian relief that the United States sometimes grants to these people who are already in the United States when things get very, very bad in their country, saying, you can stay here until your country sorts itself out and it's safe for you to return there. And prior to the Trump administration, people who are from Syria and people who are from Haiti both enjoy temporary protected status. The issue in this case, like, there really isn't any question. Like, the statute says that the courts aren't allowed to review the Department of Homeland Security's determination that a certain country should, or nationals of a certain country should or should not qualify for temporary protected status. So there really isn't any way to prevent the Trump administration from removing TPS eventually. What the issue is in this case is essentially, did the Trump administration go through the proper process when it stripped temporary protected status from Syrians and Haitians who are in the United States? And that issue, it's not a zero stakes issue. I mean, like, running through that process can take several months, and that's several months where people who, if they are sent back to their home countries, could potentially be in grave danger, will not be sent back to their home countries. But the stakes aren't as big as they could be, because I think everyone agrees, including, I mean, the lawyers for the immigrants in these cases say so in their brief, that they concede that, yeah, Trump could eventually take away temporary protected status.
We're waiting on rulings in a couple of Second Amendment cases. What was this 2022 case, New York State Rifle and Pistol
Yeah.
Association v. Bruin, that set a particular framework for presumably all Second Amendment cases moving ahead?
Yeah. I mean, the Bruin framework is very unusual. So what the court said in Bruin is that when someone claims that a modern day gun law violates the Second Amendment, the way that judge is supposed to determine whether it does or not is to go to the past, some point in the past. And the court hasn't even been entirely clear about which point in the past they should go to. But most of the cases seem to say around 1789, and look to see if there was a similar law when the Constitution was framed. And if the old law is sufficiently similar to the modern law, then the law is upheld. And if the old law is too different from the modern law, then the modern law is struck down. And I mean, the court has really struggled to articulate just how similar these laws need to be. A lot of judges, and I mean, this is very unusual to read lower court judges complaining about their, for the same reason people don't normally publicly complain about their boss. It is very unusual to see lower court judges complaining about the Supreme Court. But lower court judges have published many opinions saying, look, like, we don't understand how this Bruin framework works. Help us out here. And so the court is hearing two more Second Amendment cases where they could potentially try to clarify how this Bruin framework works. I am skeptical that this is a framework that could be made workable, but we'll see what the Supreme Court does with them.
To the specifics here, what is Wolford v. Lopez about? This is the Hawaii case, right?
Right. So Wolford v. Lopez involves a very, very aggressive anti-gun law. So it is a law that essentially says that if you want to bring a gun into a private business, a shop, a restaurant, anything like that, before you could do so, you have to get permission from the owner of the business, or at least the manager of the business. And I mean, that's an aggressive law. Like, I don't think there's too many gun owners who, if they're going to dine out, are going to walk into the restaurant without their gun, find the manager, say, hey, do you mind if I bring my gun with me? And then get permission, go back and get the gun and bring it in. So, like, as a practical matter, this law amounts to a ban. And I think if you're someone who likes the Second Amendment and thinks it should be viewed expansively, this is the kind of law that you would expect the court to strike down. The problem is that if you go back to 1789, there are actually quite a few states that had laws saying that if you wanted to bring a gun under private property, you need to have the owner's permission. So, it kind of goes back to what I was saying about how this Bruin framework is proving really hard to apply because, like, if you take the Second Amendment seriously, I think any judge who's trying to enforce gun rights would say, yeah, this law goes too far. Like, this is a very, very aggressive regulation of guns. But if you apply the Bruin framework and you just say, is there a law from 1789 that's similar?
Hmm.
Well, the answer is yes, there were laws that were very similar to this.
What about in United States v. Himani? This is basically Ken Stoner's own guns.
Yeah,
And
this
this
is
is an
yeah.
interesting one too.
Yeah, so there is a law saying that if you are an unlawful user of marijuana, then you are not allowed to possess a firearm. And there's a lot of questions in this case. One of them is what on earth is an unlawful user of marijuana? Like, if I smoked a joint in college, does that mean that I'm banned from owning a gun forever? If I go to a party in February and I take a weed gummy, do I get my gun rights back in March? Do I get them back in December? Like, it's a very vague law. So that's one problem with the law. The Bruin issue here is that the government argues that back in the framing, there were laws banning drunkards from doing all kinds of things. So if you were what was called a habitual drunkard in the 18th century, there were a lot of restrictions on you, and the government argues that that's sufficiently similar to a law saying that a drug user should not be allowed to own a firearm. At the oral argument, the Supreme Court seems skeptical of that argument. Among other things, like the definition of habitual drunkard in the 1800s, you had to be really drunk a whole lot of the time to be classified as a habitual drunkard in the 18th century. I think Justice Gorsuch had a line where he said, like James Madison used to drink a pint of whiskey every day, and he wasn't considered a habitual drunkard. So, like, it does seem like a bit of a stretch to say that, because people who drank a lot, I mean, to the point where they were often unable to control themselves, might not have been able to own a firearm at that point, that someone who occasionally gets high should have the same rule applies to them. It does seem like those laws are pretty dissimilar.
Why was the ruling in Mirabelli v. Bonta so surprising for so many observers?
Yeah, I mean, this case genuinely shocked me. So the issue in the case is California had a law which, I mean, California's laws on this have actually shifted a bit, but I think the law that was actually considered in the Mirabelli case said essentially that if you are transgender or if you're gay or transgender and you come out to your teacher, so you are a public school student and you come out to your teacher and you tell the teacher, I don't want you to tell my parents this, the teacher was supposed to honor that request. So the teacher was not supposed to out gay and trans students to their parents if the student said, please keep my secret. And the Supreme Court struck that law. I mean, they temporarily suspended. It was a shadow docket case, so they'll pick it up again. But they said that law cannot be enforced. And they essentially said that public school teachers have a constitutional obligation to out their gay and trans students to those students' parents. And what was really shocking about this is that the court relied on a theory known as substantive due process. And like substantive due process was the basis behind Roe v. Wade. Substantive due process is a theory for how judges can, some would say, create or invent, some would say merely find, but like how judges can find rights in the Constitution that aren't actually written in there anywhere. And this is a very controversial theory. The Republican Party, because it hates Roe v. Wade so much, has historically been very opposed to substantive due process. Justice Antonin Scalia, the conservative icon, one of his big issues is that substantive due process is wrong. And again, this grew out of the fact that they resented the fact that it was used to create the abortion right in Roe v. Wade. And what's so shocking about Mirabelli is that after saying for many, many years, when I was in law school 20 years ago, but when I was in law school, this is something that defined a legal conservative. Like every argument I had about substantive due process with my conservative classmates, they were against it. This was, it was really a defining issue. And now the Supreme Court has said that there is a substantive due process right to have your public school student's teacher tell you if that student is gay or trans. And that's just a big shift in how Republicans view the appropriate role of judges.
What can we expect, Ian, to come from cases involving trans women athletes who want to play on girls' teams at their schools?
I mean, we all know what the politics of like the trans sports issue is, and I don't think that the court is going to deviate that much from I think the trans athletes are going to lose here. And part of the reason why they're going to lose is not just because of the political makeup of the court. The plaintiffs in this case are pushing for an expansion of trans rights that the court previously has not recognized. So the high watermark for trans rights in the Supreme Court was a case from a few years ago called Bostock v. Clayton County. So there's a federal that forbids sex discrimination in the workplace. That's the word that the law uses, is sex. And what the court essentially said in Bostock is they said sex means sex assigned at birth. It does not mean gender identity. But if you bar sex discrimination, you can't tell someone, well, if you're a man, you're allowed to date a woman, but if you're a woman, you're not allowed to date a woman. That's sex discrimination. You can't tell someone if you're a woman, you're allowed to wear a dress, but if you're a man, you're not allowed to wear a dress. That's just sex discrimination. You can't tell a man, well, if you can't say if you're a man, you're allowed to present as a man and have a male name and do all the things that are stereotypically male, but if you're a woman, you're not allowed to do that. So like the court bypassed the question entirely of whether there are any rights that someone has because of their gender identity. And they said that when the law bans sex discrimination, that law is expansive enough that it gives some protections to people because of their sexual orientation or their gender identity. The problem for the trans athletes in these two cases, the Little and BPJ cases, is that sex discrimination is allowed in sports. Like that's why women's sports exist. The whole point is that we're discriminating on the basis of sex here. You're only allowed to join the women's team if you are a woman. And so this is a difficult case legally for these trans athletes because they can't say, well, look, you're engaging in sex discrimination here. And the Supreme Court said in Bostock that laws that ban sex discrimination also give some protections to transgender people, because this is one of the rare areas, bathrooms is the other area where we actually permit sex discrimination.
Before I let you go, Ian, I'm so curious about this. You give us your predictions here about where the court might go based on your expertise and on, observing some of these arguments as they were being made. I'm curious about whether you look at all at prediction markets like Kalshi and Polymarket and follow the sort of trends by which people are betting on Supreme Court rulings.
Oh, God, no. My God. No, I mean, like, I do, struggle sometimes. Occasionally, I am wrong with my predictions. I think that this is a court that, like, the current majority on the court is dissatisfied with a lot of longstanding precedents. So, like, if you read my stuff, often I will say, okay, if the court follows existing precedent, here's what the outcome will be. But I know that some justices have criticized this precedent, so I'm not sure that I can predict what the outcome is likely to be. But I mean, the prediction markets, like, no one who is using the prediction markets, unless the justices or their clerks are using them, are going to have any more information than I do as someone who just watches the court closely. And I just for something that I follow this closely, I'm not going to use like the aggregate of what a bunch of people who are trying to make money are going to do to figure out what I think is going to happen.
Ian Millhiser is a senior correspondent at Vox, where you can read his reporting on what the Supreme Court still has left to decide this term. Ian, thank you so much for sharing your reporting.
Thank you for having me.
Think is distributed by PRX, the Public Radio Exchange. Again, I'm Chris Boyd. Thanks for listening. Have a great day.